Hi, Suzy Rhoades with PassMasters here with this week's Questions of the Week. This week's video will help you whether or not you're preparing to take the Series 65, Series 66, or Series 63 exam. This is a section exam about law. So 65 and 66, that is your investment advisor representative exam. These exams have the same exact content for Section 4. It is just slightly more questions on the 66 than it is on the 65. If you're taking Series 63, your entire exam is law. It's going to be heavier weighted towards agents and broker-dealers, but it's the same content. Let's practice this section exam. All are true regarding investment advisors' disclosure obligations as a fiduciary, except what is false. An advisor can never be required to disclose more information than the information required on Form ADV Part 2A. Seems false. When an advisor cannot avoid conflicts of interest, full disclosure to the client is required. That is true. An advisor must disclose all material facts relating to the advisory relationship. That is also true. An advisor must seek to avoid conflicts of interest with its clients. That is true, but they are allowed so long as they are disclosed. So this is the false statement. So it's right because it's wrong. So you click what you believe is the correct answer, click check answer. You know you got it right if you get that green check mark. You click show explanation. You can read the rationale and you can also listen.
All are true regarding an investment.
All of our questions have audio explanations. You are an investment advisor representative. Your business is booming, so you hire an administrative assistant to help you. Your assistant may do all of the following without registration as an investment advisor representative, except, so what can't they do? Discuss investment options with clients? They can't do that. Let's check the other three though, make sure they can do those. Set appointments? Yes. Engage in clerical work? Sure. Answer phones? Yes. They are not allowed to discuss investment options with clients unless they are properly registered. Law questions are often this format where there are multiple questions. Just slow down. They're like 4 true false questions. Under the Investment Advisors Act of 1940, which of the following are allowed in advertisements? So this is under federal law. The use of testimonials is allowed under the marketing rule. So 1 is part of the correct answer, so I can get rid of A and B. 2, representing that one chart or graph can be used to decide which securities to buy and sell. That is allowed today, as long as the firm actually uses that chart or graph. Referring to past recommendations made is allowed. Stating that an advisory service will be provided for free when there are no strings attached. That is also allowed. So all 4 of those under federal securities law today are allowed. A person who provides advice to others about investments for a fee is a broker-dealer, agent, investment advisor, or investment banker. Remember, person is broadly defined. It does not just mean you, an individual, living, breathing, natural person. It can mean a firm as well. This is describing the investment advisor. The SEC requires on the front of every prospectus a specific non-approval clause. This non-approval clause acts as an effective date, an approval, a disclaimer, or a representation clause. Oh yeah, it's a disclaimer. It is relieving the SEC of any liability related to this offering. When developing a program to protect against identity theft, which is the most important step, to prohibit the agents from using mobile devices, to send out a privacy notice, to set up procedures to detect red flags, or to encrypt all emails. So what would be the most logical, important step here? So to protect against identity theft, I'd want the broker-dealer, the investment advisor, to have procedures set up to detect red flags. A broker-dealer with no place of business in this state could do business in this state without registration with all of the following except broker-dealers, insurance companies, retail clients, or banks. Which one of these things does not belong here? Sesame Street was my favorite show as a kid. My mother hated it. I still love it. Which one does not belong? Retail clients. So the minute a broker-dealer has a retail client in a state, it must be registered in that state. If it doesn't have an office in that state and it only does business with institutional clients, then no registration in that state is necessary. Sorry for my horrible singing. Which of the following regulations governs privacy of customer information as it relates to the financial services industry? It is Regulation S-P. It is the Financial Services adoption of the Gramm-Leach-Bliley Act. Of the following investment advisors, which would be required to register federally? An investment advisor whose advice is limited to securities issued by the federal government. An investment advisor with $150 million in assets under management. An investment advisor who only advises clients in her own state and whose advice is only related to securities sold within the state, or an investment advisor whose clients are insurance companies. Of those four, which one's required to register federally? So we have $100 million in assets under management when the firm is new. If it has that $100 million or more in assets under management, they register federally. So this is the $150 million they'd have to register federally. So after the initial registration, there is a 20% buffer as far as when do they have to switch. The other three can register at the state level. An advisor states in an advertisement that it has more than 100 clients that have stuck with me for more than 10 years. Under the marketing rule, which of the following is true? This is a legal statement. This may create a misleading implication, which is prohibited. This is considered a misleading statement, or this is not considered a misleading statement. Okay, so let's think about it. More than 100 clients that have stuck with me for more than 10 years. What about the other 400 clients? So you just don't know, do you? So this may create a misleading implication, which is prohibited. That's the best choice. This is under the marketing rule. Under state law, an investment advisor that does not have discretionary authority over a client's funds and or securities or custody, but does accept prepayment of fees of more than $500 per client 6 months or more in advance, must maintain a minimum net worth. That is positive is the correct answer to this question. So they don't have custody, they don't have discretionary authority, but they do accept prepayment of fees of more than $500 per client 6 months or more in advance. They must maintain a minimum net worth that is positive. Regarding the anti-fraud provisions of the Uniform Securities Act, which is state securities law, of course, which of the following is true? Exempt securities are covered, non-exempt securities are covered, registered securities are covered, or all securities sales and offers are covered. So which is the most correct answer? Because there's some correct answers in there. It is anti-fraud provisions apply to everything. All securities sales and offers are covered. So whether or not they're registered or not, it doesn't matter. A federally registered investment advisor includes performance results in its advertisement. Which of the following is an untrue statement? Performance results must be presented for 1, 5, and 10-year time periods. An advisor may highlight the 1, 5, or 10-year period that shows the best performance. Time periods must be presented with equal prominence, or if gross performance is shown, net performance results must also be included with at least equal prominence. So we're looking for the untrue statement. An advisor may highlight, that is not true. An advisor may not highlight, no. A person advertises investment advisory services. Which of the following is true? This person must register as an agent. This person is exempt from registration. This person must register as an investment advisor. If this person actually gives investment advice, they must register as an investment advisor. If you advertise investment advisory services, you, person, broadly defined, you must register as a firm as an investment advisor. I don't care if you've done it yet or not, you must register as an investment advisor. Which of the following are valid reasons for the administrator to cancel the registration of an agent? If the registrant cannot be located, if the registrant is deceased, if the registrant has ceased to do business as an agent, or if the registrant has been deemed to be mentally incompetent. Those all seem like valid reasons to cancel the registration of an agent. In which of the following situations is the investment advisor required to deliver a brochure and related brochure supplements? 1. To clients who receive only impersonal advice and who pay less than $500 in fees per year. They are not going to be required to deliver a brochure for Roman numeral 1, so that is not part of the correct answer, so I can get rid of C and D. 2, to clients who receive only impersonal advice and who pay $500 or more in fees per year. Yes, so that is the threshold. So 2 is part of the correct answer. 3, to clients that are investment companies registered under the Investment Company Act of 1940. No. 4, to clients who receive personal investment advice regardless of how much they pay a year. Yes, so the correct answer is 2 and 4. Federally covered advisors need not register in any state. The firm's investment advisor representatives are exempt from state registration, required to register at the state level, required to register federally, or required to register both with the SEC and the state. IARs register at the state level, regardless of where the firm is registered. An investment advisor who manages mutual funds must register with FINRA and the SEC, FINRA, the SEC, or the state. The investment advisor of a mutual fund must register with the SEC. In which of the following situations may an investment advisor discuss client identities and affairs? With permission of the client? True. At any time? False. As required by law to do so? True. If the client is deceased? False. So 1 and 3, those are the correct choices. An individual who is applying to be an agent would be subject to statutory disqualification for which of the following? Being convicted in the past 10 years of a securities violation, that would subject them to statutory disqualification. Yes. 1 is part of the correct answer. I can get rid of D. 2. Being convicted in the past 10 years of a misdemeanor involving finance dishonesty, embezzlement, bribery, forgery, or theft. Yes, that would subject them to statutory disqualification. So I can get rid of C. 3 is part of both A and B. Let's check it. Being convicted in the past 10 years of any felony. Yes. Being expelled or suspended from FINRA would be grounds to be statutorily disqualified. Yes. So all 4 of those, B. All of the following should be red flags for online investors except, so what would not be a red flag? The promise of high returns with no risk, red flag. No real information on the website, red flag. No written information is available, red flag. A company website that includes information on how to reach FINRA, that would be great. That would not be a red flag. When an investment advisor uses a qualified custodian to hold clients' assets, which of the following are true? The advisor must send quarterly statements to the client. That's 1. 2, the qualified custodian must send quarterly statements to the client. Okay, so it's either 1 or 2. It is, in fact, 2. So 1 is not part of the correct answer. 2 is part of the correct answer. I think I know the answer, but keep going. There is a requirement for an annual independent surprise audit under federal law. The qualified custodian must keep the money and securities in the client's name. So I think you'll learn to love these multiple questions. We knew that 1 was not true, 2 was true. So 1 was not true, we got rid of A and D. 2 is true, that left us with only B as the possible right answer. So 2 only. So that is the only true statement. The qualified custodian is allowed to maintain funds either in separate accounts for each client under the client's name or in an account that contains only one specific investment advisor's client's money and securities. The annual independent surprise audit, it's not federal law, it is state law that requires that. So that's tricky. Tricky law questions. You better believe it. Consent to service of process is filed only at the federal level, optional for investment advisors, filed only in the home state, or required to be filed in every state in which the investment advisor registers. That is correct. Consent to service of process is filed to create jurisdiction across state lines. It is only filed upon initial registration. It's not filed again, but it's required in every state in which the advisor is registering in. A written margin agreement must be obtained from a client promptly after the initial transaction in the account. That's true. It's a really weird rule. Most firms are not going to wait to get it until after, but the law is written in this very specific way. So promptly after the initial transaction in the account. Every offer of a right to purchase or subscribe to another security of the same or another issuer is considered an exempt transaction, a sale, an offer and a sale, or an offer of the other security. Every offer of a right to purchase or subscribe to another security is an offer of the other security. I know they talk so strangely in these law questions. It's a matter of practice. Waivers signed by clients are enforceable in court, relieve advisors from legal liability, do not absolve advisors from legal liability for unethical or prohibited business practices, or may help in the case of intentional omission of material facts. Waivers like, hey, let's go break the law. You can't sue me later. Do not hold up in court. They do not. An investment advisor may charge both a commission and a fee with proper disclosure to the client. Other choices, so long as the total isn't more than 2% of the assets under management, never or with permission of the administrator. An investment advisor, it's very common that products that they recommend, they collect a commission on, and then they charge an asset-based management fee. It is allowed with proper disclosure to the clients. Which of the following falls within the definition of recommendation? A broker-dealer sends to its clients an email urging them to invest in a specific sector of the market, providing them with a list of suitable stocks. Seems like a recommendation. Let's check the others. A broker-dealer has tools on its website that allows customers to search for listed securities. No. The broker-dealer sends emails to clients based upon stocks the clients have chosen to receive news about. No. The broker-dealer provides clients with access to research reports. No. The only one that falls within the definition of a recommendation. It's specific. When a securities order is placed by an investment advisor pursuant to oral discretion, the client must provide written discretion within how many days of the first trade? So it's super interesting that an investment advisor is allowed to place a trade based upon oral discretion, but they must receive written discretion within 14, 10, 90, or 30 days. Within 10 days. So they place the first order and they can place other orders for that 10-day period. But after the 10 days, if it's not received in writing, then no further discretionary orders may be placed. A client would like to engage in options trading. The client must be furnished with which of the following? Hypothecation agreement? No, that's margin accounts. Client contract? ODD or OCC? OCC is the Options Clearing Corporation. They guarantee listed options. The ODD is the options disclosure document the client must be furnished with if they would like to engage in options trading. SEC Rule 147 allows for the registration of securities by justification, by coordination, by filing, or by qualification. SEC Rule 147 is the intrastate in one state offering rule. If a security is going to be sold in one state only, it is going to file for registration by qualification. Qualify in a state. Which of the following is or are not subject to Regulation S-P? Cookies that collect aggregate information only, consumers, customers, or institutions. All right, so let's think about it. Regulation S-P is the privacy requirements, and part of the privacy requirements is that annual privacy notice. So consumers and customers are subject to this privacy notice. It is the customer who gets it annually. Institutions are not subject to Regulation S-P. It's also true that cookies that collect aggregate information only are not subject to Regulation S-P. If it was collecting specific identifiable information, then it would be. So which ones are not subject to Regulation S-P? 1 and 4. Under the Uniform Securities Act, state securities law, which of the following would be required to be registered as an investment advisor representative? A solicitor that is employed by the investment advisor and paid a fee for her service. Yeah, sometimes we call these people today finders. So I think that's right, but let's check all 4. An individual who charges a fee for advice relating to investing in precious metals? No. An agent who offers investment advice to his clients without charging a separate fee? No. An employee of an investment advisor who performs clerical functions and has a Bachelor of Science in Finance? The only one of these that would be required to be registered as an IAR is the solicitor or finder that is employed by the investment advisor and paid a fee for her service. An individual who makes investment recommendations, manages accounts, solicits investment advisory services, or supervises others who perform these duties must register as an investment advisor. No, that's the firm level. Broker-dealer, also a firm. Investment advisor representative or agent. So an agent's going to buy and sell securities for the client. This person is making investment recommendations, managing accounts, and soliciting investment advisory services. They must be registered as an IAR. When a broker-dealer does business on the premises of a bank where retail deposits are taken, which of the following correctly describes the disclosures that must be made? 1, the disclosures shall be made orally and in writing. That's true. So 1 is part of the correct answer. I can get rid of C. The disclosure must include the fact that the securities products being purchased are not deposits of the bank and that there is no FDIC coverage for the purchase. 1 is true and 2 is true. So I can get rid of A. B and D both have 3 as part of the correct answer, but let's read it anyway. The disclosure must include the warning that investments are subject to risk, including the possible loss of principal invested. That is true. 4, the disclosure must be signed by the client during the account opening process. That is actually false. The disclosure must be given, and great if they sign it, and if they don't, that's okay too. Strange, I know. So 1, 2, and 3 are correct. The broker-dealer must make reasonable efforts to obtain a signature, but if they don't, they're not going to get in trouble. Under the Uniform Securities Act, an offer is made in a state when 1, it originates in that state. Yes. It is contained in a newspaper published outside of the state. No. It is broadcast by radio or TV from outside of the state? No. So of those three, an offer is made in a state when it originates in that state. That's the only correct answer. So advertisements, newspaper, radio, TV, is regulated by the originating state only. Which of the following is held to a fiduciary standard? Agents, dealers, brokers, or investment advisors? It is the IA that has to follow fiduciary standards. Broker-dealers are held to a suitability requirement under FINRA rules. In general, advisory fees must be a flat fee, must be an hourly fee, must be a percentage of assets under management, or may not be based solely upon performance. So what's the best choice here? In general, advisory fees may not be based solely upon performance. That would be called a performance-based fee. They are allowed in very specific circumstances, but in general, they are prohibited. Under state and federal law, banks are excluded from the definition of investment advisor, required to register when assets exceed $500 million, included within the definition of investment advisor, or required to register as broker-dealers. Under state and federal law, banks are excluded from actually both the definition of investment advisor and the definition of broker-dealer. They are excluded specifically. What are broker-dealers required to have in place to detect money laundering and ensure that the appropriate procedures are followed? Registered principal, red flags, anti-money laundering compliance program, or FinCEN auditor on staff. It is the anti-money laundering compliance program that is designed to detect money laundering and ensure that the appropriate procedures are followed. Regarding net capital requirements of a broker-dealer, which statement is correct? The net capital requirement is less the longer a firm has been in business. False. The state administrator cannot require a broker-dealer to have more in net capital than the SEC. I like that. Let's check the other two. Better be false. The net capital requirement is designed to protect the SEC. No, it's designed to protect the customer. The state can require the broker-dealer to have a higher amount of net capital than the SEC. That's false. So the correct statement, the state administrator cannot require a broker-dealer to have more in net capital than the SEC. Broker-dealers are registered with the SEC and with the states. The states cannot require more in net capital than the SEC. That's true. Which of the following would not be required to be registered as an investment advisor representative? Persons who solicit advisory business would be required to be registered. Persons who train investment advisor representatives. Persons who supervise investment advisor representatives, or persons who manage client accounts. It is persons who train investment advisor representatives that are not required to be registered as IARs. If you train agents, you must be registered as an agent. But if you train IARs, you do not have to be registered as an IAR. Silly law. Which correctly describes directed brokerage? 1. When the investment advisor routinely recommends, requests, or requires that a client direct the firm to execute transactions through a specified broker-dealer. Yes. 1 is part of the correct answer. I can get rid of B. 2. When the investment advisor allows the client to choose which broker-dealer the investment advisor must use to execute transactions, that is also true regarding directed brokerage. So 1 and 2 can get rid of D. 3, when the investment advisor has the ability to access clients' monies or securities, that's custody. 4, so that was 3. 4, when the investment advisor can choose which securities to buy and sell for the client, that's discretion. So the two that correctly describe directed brokerage are Roman numerals 1 and 2. 3 was custody and 4 was discretion. This is very much like a law question, long and wordy. So, the whole test isn't like this, but these law exams do like long questions. The Investment Advisors Act of 1940, Rule 2064-5, applies to SEC-registered investment advisors who provide investment advisory services or are seeking to provide investment advisory services to government entities. This rule is designed to curb pay-to-play activities. This rule prohibits which of the following? So we don't want to be able to give money to municipalities in the hopes of getting the investment advisory business. That's what this rule is all about. Which are prohibited? 1, an investment advisor from receiving compensation for services rendered to a government entity, either directly or through a pooled investment vehicle like a 529 plan for 2 years after the advisor of certain of its executives or employees made political contributions above specified thresholds to an elected official or candidate for political office, if the office is directly or indirectly responsible for or can influence that government entity's selection of the advisor. That's true. So that would be prohibited. So 1 is part of the correct answer. I can get rid of A. 2, an investment advisor and certain of its executives and employees from paying or agreeing to pay a third-party placement agent or finder to solicit business from a government entity on the advisor's behalf, unless the third party is a registered broker-dealer or SEC-registered investment advisor subject to pay-to-play restrictions. That is also prohibited. So 1 is prohibited and 2 is prohibited. That gets rid of B. So 3 is part of both C and D, so let's check it out. An investment advisor and certain of its employees from soliciting or coordinating contributions, that's called bundling, from others to a political official, candidate, or political party in a state or locality where the advisor provides or is seeking to provide advisory services. That would be also prohibited, yes. So the question really is 4 included. An investment advisor and certain of its employees from volunteering and making speeches in support of officials of government entities who can influence the hiring of an investment advisor. There is no prohibition or rule related to simply volunteering. It's always related to pay money. So 4 is not part of the correct answer. So C, 1, 2, and 3. Under NASAA rules, NASAA is the North American Securities Administrators Association. They are the ones who are in charge of the 65, 66, and 63 exams. Under NASAA rules, in which of the following situations may an IAR borrow money from a client? 1, the client is a bank. 2, the client is a broker-dealer. 3, the client is a fellow employee at your firm. Or 4, the client is a mortgage broker. You don't borrow from a mortgage broker, do you? No. IARs are allowed to borrow money from a client who is one of these 3. So is a bank, a broker-dealer, or an affiliate? A client is an affiliate. So a fellow employee at your firm would be considered an affiliate. When you're done, you click Finish Exam. Yes, we passed. Click View Score Report. It shows you the section of 65 and 66, the entire 63 exam, laws, regulations, and guidelines. And then you click this down caret and you see all of the topics that were covered. So these are all of the topics on the content outline for this section for 65, 66, and the entire 63 exam. So these are all of the topics that I will cover in my PassMasters course. That was a long one. Great job hanging in there. Law questions can be tricky and wordy. Give this video a thumbs up. Be sure to subscribe to our channel and turn those notifications on. If you have any questions at all related to this topic, ask me in the comments below. If you would like to check out PassMasters course offerings or to enroll in any of our programs, there is a link found in this video's description. Thanks so much for hanging in there with me. I hope to have you as a student soon. Happy studies. You got this.